Hello, and welcome to the first seminar in the LAMDA Introduction to CCB work. And this is an excellent series. We are going to have 7 parts to this series, going through all the nuts and bolts of doing consent and capacity board work. This first intro session is all about the area of CCB law. What does consent mean? Capacity? How do you start with a file? And then the next seminars within this series will go through in more detail capacity, involuntary admissions, community treatment orders, other miscellaneous applications, preliminary issues, as well as a full mock hearing. So tonight's seminar is going to be an introduction to consent and capacity board work. My name is Shira. I am a lawyer at Brass Law Office focusing on criminal law and consent and capacity board work. And we are here with Anita Szigeti, who has over 30 years of experience in criminal law and consent and capacity board work with a focus on mental health. She is a multiple times published author and a force to be reckoned with. We are so lucky to have Anita here tonight. She is also the president of LAMDA, and we are so pleased. So what we should do now is let's go right into the questions. And Anita, I want to ask you, can you begin by flagging some of the resources for lawyers who want to practice CCB work?
Thanks, Shira, and thank you so much. This was actually your initiative for LAMDA and your idea, so thank you so much for helping me to do this very first session, which is just an introduction to the practice before consent and capacity board. And we're doing it at least initially for LAMDA members, and then we'll see who finds it popular. Maybe, you never know. So just to let everyone know, I plan to post this video to my own WordPress blog, where you'll find a lot of other resources, podcasts, and webcasts that will help you to represent clients at the CCB. I'm also going to provide some materials to go with this video. For now, I think only to LAMDA members. So if you're not a member of the Law and Mental Disorder Association, those materials will not be available to you, at least initially. But if you join the association, which is free, you can request access to the materials in that event. There are 2 textbooks that I'm going to recommend that everyone who practices before the Consent and Capacity Board purchase from LexisNexis on their website. I actually don't have them here. I had planned to hold them up, but I forgot. So they are my books, but it's not because I want to get rich off your purchase, believe me. It is the Consent and Capacity Guide, or a guide to consent and capacity law in Ontario, 2024, and the Law and Mental Health in Canada cases and materials. The Law and Mental Health in Canada is for law students and beginners and new lawyers. The CCB guide is for the lawyer representing clients at the CCB on the daily. There's also a 3rd book that's coming out this summer that is for advanced practitioners. So you may not be there yet, but for those who are really immersed in mental health and the law, including practicing civil mental health and consent and capacity board work, it will be called the Canadian Anthology on Mental Health and the Law. So like I say, my blog has a ton of stuff linking to all kinds of podcasts and webinars and other good resources. And the materials to go with this session will include a checklist and a cheat sheet and all kinds of neat things that I think practitioners will find helpful.
And this series is in no way a plug for Anita's books, but I will say, as a lawyer practicing consent and capacity board work, her books are an incredible resource, and they are essentially a Bible to look at when you're engaging in this work.
That's very sweet of you to say. In case anyone's feeling like they're being asked to make me rich, I have been getting my monthly royalties checks, and one of them was for, I think, 40 cents. One of them was for $6. Sometimes it's $24, and I get pretty excited about that. So this really isn't a profit-making venture, but I think you'll find it helpful. So thank you, Shira, for saying those very nice things. Those are some resources.
And so getting into consent and capacity board work, what are the types of cases handled before the CCB?
So the Consent and Capacity Board is a provincial tribunal, and it's established under the Healthcare Consent Act, which adjudicates civil mental health matters in Ontario. The three most commonly heard applications are related to involuntary psychiatric committal, treatment capacity, and community treatment orders. Every time a patient is involuntarily detained on a new form of committal under Ontario's Mental Health Act, they are entitled to file what's known as a Form 16 application under the Mental Health Act to review their involuntary status. Also, under the Mental Health Act, every time a community treatment order is issued or renewed, so once every 6 months or so, the subject of that CTO is entitled to apply by way of a Form 48 application to have the criteria for the order reviewed to see if they apply to the person. And finally, under the Healthcare Consent Act, a person whose doctor has found them not capable of making their own treatment decisions can apply using a Form A application to have that finding of incapacity reviewed. Now, beyond these three applications that make up probably 75 to 80% of the applications the CCB receives, they also hear reviews of incapacity findings under the Mental Health Act or the Substitute Decisions Act, and review other incapacity determinations related to disclosure of personal health records and other issues. They also review the decision-making process of substitute decision makers in mostly end-of-life cases called Form G applications under the Healthcare Consent Act, and applications to appoint representatives for healthcare decision-making by way of what's known as Form B and C applications under the HCCA also. So in total, Shira, the Consent and Capacity Board, believe it or not, receives about 30 different types of applications arising under 6 or 7 different provincial Ontario statutes.
Okay, and so you've described an array of files that we can hear before the Consent and Capacity Board. You get a new file. What's the first thing that usually happens?
Right. So usually you would first hear from a rights advisor for the hospital where your client is, advising you that a client wants to retain you. When I get that call, I think it's important to extract as much information as possible from the rights advisor regarding our client's application to the board during this first call about that client. It's helpful to have a checklist. I'm a big fan of checklists and tables and charts and to-do lists. So I will want to know when a certificate of involuntary admission or its continuation was completed. What's the date on the form? Because one of the things you want to know is when that form expires. Sometimes you don't get called when it was signed, but rather halfway through the life of a 2-week form, and you need to know what is the last day to schedule the hearing so that the application doesn't become moot. Or when was a finding of incapacity made in respect of my client, by whom? When the application itself was completed and forwarded to the board, I will ask for the telephone number where I can reach the client, the phone number for the nursing station on the unit, a direct telephone number of the attending physician for my client, the name of the doctor and contact information, an email address for that doctor is really important. I need to know whether a legal aid application has been taken from the client, as well as whether there is likely to be an issue as to the client's eligibility for legal aid. Even if there is an issue with financial eligibility, the board can sometimes make an order for counsel for an unrepresented person, but that lawyer may not be you. So you want to have a heads up if the client is not eligible for legal aid, because you may have to speak to the client about a private retainer, although that's a conversation that we would have to really think about in terms of whether they're able to have that conversation. Anyway, sometimes the rights advisor will have spent a great deal of time with your client already and will have some special concerns of your client to relate to you, or other helpful information about how you best communicate with the client or when. For example, do they need an interpreter or ASL or deaf interpretation or both? Any other communications barriers or accommodations that are needed. So there are a lot of things that you can ask the rights advisor and information that they can provide. And a lot of people just kind of pick up a voicemail or get an email and don't follow up, but the rights advisor can set you up for success with your client with all the information that they can give you.
That's really great. And then how do you get retained on a file? You'd mentioned legal aid. So what happens?
So the rights advisor likely and will confirm if they have forwarded an application for legal aid from your client. And really almost all clients who are going to have a consent and capacity board hearing are going to be financially eligible for legal aid. Most of them will be receiving Ontario Disability Support Program funds, so they're eligible financially. And in that event, you simply get a certificate from legal aid in your portal. Now, sometimes it takes some time to process that, and we have to turn our cases around really quickly. The board convenes, as you know, Shira, within 7 days from the date of application. So we, don't tend to wait for confirmation that legal aid certificate is coming. Historically, if we end up doing a hearing and we didn't get a certificate, we have been able to get legal aid to issue us a certificate retroactively in the rare case where there's a problem, but don't quote me on that. So legal aid is generally available. Where it's not, and sometimes legal aid will ask you to see whether you can enter into either a private retainer or a compensation payback agreement with legal aid. And that can get tricky because your client may have been found not capable to manage their property, in which case it would be unlawful for you to negotiate with them for payment of your retainer, rather than through the public guardian and trustee. So sometimes you have to speak to their representative at the public guardian and trustee if their money is being managed by the PGT. And sometimes you have to speak with family if they're managing the client's money. But most often, if the client's not able to enter into a retainer agreement, or you don't feel comfortable because you have concerns about their capacity to retain you in that way, you just advise legal aid about that, and they are most likely to issue a certificate given the urgent nature and the importance of CCB hearings. So by and large, legal aid will cover you in this one area of law.
Okay. And then we've spoken about getting retained, but then once you're retained, you might start on your file before getting retained. You have a phone call with your client, presumably. What information do you discuss during your first contacts with your client?
That's a really good question, Shira, and it's important. I can tell you what I do. My practice is always to speak with our client before I get their health records in, and before I read what the doctors and nurses and other people have to say about my client, because I don't want my opinion to be influenced by those charting notes and entries. So after getting some basic information about the client from the rights advisor, I would then reach out to the client for that initial conversation. It's just the first of at least 2, probably more further conversations before the hearing. So at minimum, in terms of the ground that you have to cover when you have that first conversation with the client, at minimum, there's certain information that you must give to your client. So number one, you have to explain to your client what the hearing will be about, what they've applied for, what the board is going to do to review their legal status. Are they going to review whether they have to stay in hospital or not, or whether they can make their own decisions about their medications or not? So you explain the nature of the hearing to them. You also explain what the hearing is not about. So sometimes there are things that are within the hospitals or the physician's discretion that the board can't do anything about, and your client just wants smoke passes, or they want a different diet, things that an advocate can maybe help with, but the board generally can't help with. So you explain that. You tell them what the board can and cannot do. what decisions they can make at the end of the day. You explain who the consent and capacity board is, so that they know what they've just signed up for, that there'll be a psychiatrist, a lawyer, and a community person usually on the panel. You tell them when to expect the hearing, roughly, within 7 days. And these days you have to tell them that, generally speaking, by default, the hearing will be held on Zoom or even by phone, because in-person hearings are not happening at the CCB right now, although in some special circumstances, you can make a request for an in-person hearing. So you tell the client about the process of the hearing. The court reporter will be making a record. You explain that the doctor has to prove whatever it is. So you would talk in plain terms with your client. You say, look, we're going to have this hearing and the doctor is going to have to show up, and they have to prove to this independent decision maker who comes to hear your case why you have to stay in hospital. And if they can't prove it, then you get to leave. You explain to the client they don't have to prove anything. Tell them they don't even have to come to the hearing. They have the right to be there, but they don't have to. One very important thing, because you may never get them on the phone again, particularly if you're doing a community treatment order hearing and they're in the community and they feel like they've applied and they've hired you and then they just want to forget about it, you may never be able to get them back on the phone again. So at the initial hearing, I do canvass them about if that happens, and I review their record and I have a theory of the case and I know what they generally want to accomplish. Can I go ahead with the hearing without them in attendance? And if they say, yeah, if I don't call you back or I'm going to be away, I don't care, you go ahead and do the hearing. Sometimes that's a real option and sometimes that's what they want. So get instructions about whether or not you can proceed. If you can't get a hold of them, if they don't show up, if they don't call in, if the hearing is up and you need to go ahead without them, can you do that? Because otherwise you're going to be caught in a series of endless adjournments sometimes. So you tell them all that. You tell them they have the right to testify when there's a hearing, but they don't have to. And the big thing you want to tell them when you call them is you tell them you're their lawyer and you're going to be back to them with specifics, but you're there to assist the client to reach their goal, whatever it may be, and that you will be asking the doctor questions on their behalf and probing the doctor's theory of what they're trying to do to your client, and you're going to stand with them and up for them. So your question might have initially been, Shira, what do you want to know from the client? This is just the information you give out to them. But in terms of information that you have to get from the client, you want to get their initial story of why they're in hospital, if they're in hospital, or how they came to be on a community treatment order, if they're on a treatment order, how that came to be. You want to get some basic information about your clients so that you have a sense of who they are and how they like to communicate. Are they the type to joke around? Are they awfully serious? Are they scared and anxious about hearings? Want to just kind of get a flavor of the person. Some very basic information about who they are, where they live in the community. Who do you live with? Your parents? Are you married? Any accommodation needs for the hearing? Again, interpretation, any other communications barriers. You want to get contact names and numbers from your client about anyone that might potentially be a supportive witness, because it's going to be hard to track them down and explain what you need. So if your client thinks that they will have a family member or friend who could testify for them, you get that information at the outset. And then you sort of find out what it is they're looking for. Oftentimes with, for example, an involuntary admission hearing, your client really just wants passes. They want to smoke, or they want day passes, or they want to go home, but they're prepared to stay in the hospital. And that's something we see really frequently. My view is if a client is prepared to stay in the hospital voluntarily, then the doctor should change their status to voluntary patient and settle the hearing that way. I don't think you should withdraw applications for hearing when your client is truly prepared to be voluntary. So it's important to get sort of a sense of whether there's something to negotiate there with the doctor in advance of the hearing. And in that regard, finally, you need to ask your client if you have their consent to speak with their psychiatrist or with their family, and who they would consent to you speaking to in preparation for the hearing. And also, if they have any documents that they want you to have for the hearing, like you ask them, is there anything you need me to see? Any notes that you've made? Um, anything about this hospitalization? Any text messages? Is there anything that I'm going to be seeing from the other side? Let me know, and you get them to get that to you by text or by email. That's a lot, but it's important to get a lot of information from the client at the outset. Yeah, so that's where the first contact takes me.
And do you also get background information from them about their medical history, their diagnoses, if they have a substitute decision maker, and other information that can come up at the hearing?
Yeah, so you know what? That's a really good question. Actually, that never occurs to me. So everybody has their own approach. I I don't think I ever talk to my clients about this stuff until much later, when I'm able to have the conversation in a different way. So I'm always reminded of, I used to have a really good friend that wanted to try to work in CCB work and do mental health, and I was really encouraging him to do it. And then he finally got a client down here at CAMH. This was like 20 years ago. And he called me and he said, I'm going down to see my first client at, Queen Street Mental Health. And like, honestly, 5 minutes later, he called back and I said, what happened? He said, oh, he fired me. And I said, oh, what'd you do? Like, what happened? And he said, oh, I read his records and I figured, oh, he hadn't done anything wrong. They just wanted him to take his medications. That's all. He didn't do anything. So I said, he was in seclusion. So I went down to see him and they let me in there. And I said, why don't you just take your medications? And then the client said, you're fired. So I don't engage the client on diagnosis or treatment history or their psychiatric history, not off the bat, because I think they get enough of that. Every time they talk to a psychiatrist, it's always, what's your diagnosis? Do you agree you have schizophrenia? What medications have you taken? Will you take this medication? I worry about that later when I've read the record, and that's a different conversation. I don't even think about that stuff. I'm just interested in getting to know the client as a person at first, and getting some very basic instructions, which will generally consist of, I don't want these medications, or I want out of the hospital or something. So I just know where we're going, but I would wait with that for the next conversation.
Okay, and so let's talk about some of the steps that might take place between this first phone call and the next conversation. So once you've spoken to the client, what are the next steps you take when you get a new case?
Right. So the next step is always to get access to the client's health records. This may prove problematic in some contexts, but the board has made clear to psychiatric facilities that they must provide electronic records access and copies now that the CCB hearings are virtual, held by phone or by Zoom. Phone's a real treat. I think they're transitioning to all Zoom, which is certainly an improvement over teleconference proceedings of this tribunal. So there's actually a letter on the CCB's website that went to all chiefs of psychiatry at Ontario hospitals to this effect, and that's very helpful. You can send that along to hospitals if you have any trouble getting health records. But basically, you contact the health records department or the personal health information privacy department of the hospital where your client is, and you indicate that you're counsel and there's a consent and capacity board coming up, and your authority to access and get copies of that health record is through Section 76 of the Healthcare Consent Act. You have an automatic right of access to the client's records in preparing for a hearing. There should be a nominal or preferably no fee. If there's difficulties with this, you can suggest that they call the consent and capacity board to confirm your authority to get the records, and they often do help you. If all else fails, you can get the board to issue a summons to witness and a subpoena for the documents. It's gotten that far a few times for me over the many years, but not often. Then you make the request for all of your clients' health records, certainly on the current admission, but you may want historical records from other facilities that they have a copy of as well, and you make sure you get all the records. In this electronic health records era, should be warned that this could mean literally thousands of pages of psychiatric records that you will receive most often through a secure portal or by email. In the context of community treatment orders, you may have to obtain records from more than one facility, not just the one that's issuing a first community treatment order, but other hospitals where your client may have been a patient to determine if they meet the eligibility criteria. The other thing around getting access to records is some hospitals will insist that you get a written consent from your client to release those records to you. My advice to you on that is do not comply with that request because it's not necessary in law, and we don't want to train the hospitals to require things they're not entitled to. So just tell them they don't need that consent. Even if your client's prepared to give it, don't provide it. So that's how you get access to the records, and that's the first thing you really need on the file.
Okay, and then building off of that, is there generally a time frame that you look at for records? So you said for involuntary admissions, you would ask for records from definitely the start of this admission, possibly prior admissions. And based on the type of issue before the board, do you have timeframes for records that you request?
Yeah. So, if it's a client who we know well, who's been in hospital for a long time, and every 6 months, they like to review a finding of incapacity with respect to treatment, then we would just get, that 6-month period, maybe that we don't have. We often build records. We have our own library of secure records for clients over time. So, the last 6 months to a year, if they're in hospital for a long time, it depends what the issue is. Sometimes we've had a hearing, maybe we represented this client a couple of months ago on a Form 3, and now they're on a subsequent Form 4. So we'll get updates from, the last date. So it depends. I mean, if a client has like a 25-year history, you can't get every health record that they have at the hospital, because there was a case actually where with one client, Waypoint, where the client had been for a long time, told us that the health records were 81,000 pages for a CCB hearing, a mandatory Form 17 review. And we said we don't want 81,000 pages, so we negotiated it down to 14,000 pages. And I think in the end, they sent us something like 8, and we couldn't review them all. So you do have to be prepared for an onslaught. But I think it depends. I think in a capacity or CTO, you want to see the last number of months. For an involuntary admission, if it's a Form 4, you just obviously want to see the whole admission. It may just be the last month or a few weeks. So it depends. What about you? Do you have any particular timeframes in mind?
When I've been doing CTO hearings, I usually ask for the last 6 months, and depending on what comes up in those records, I'll ask to go further back. And then for the involuntary admissions, I find definitely at least from the start of this admission, no matter how long the admission has been. And then looking at the records, let's say a patient was made voluntary, stayed in the hospital, and was subsequently issued a new form, then I'll look for all the records from the start of their admission and possibly going back to for prior admissions, especially when it's clients that have been admitted, then issued a Form 5, they've been discharged, then formed again a few days later, discharged, formed again. You want to see the history.
Makes sense.
Yeah, that is especially useful. And then, so we're talking about the medical records. What is it that you're looking for in the records?
So let's talk first, I think, about some technical requirements of whatever the doctor or the hospital has done to remove rights from your client. So you're looking through the legal forms. First of all, I look through the legal forms, first of all, looking for, so-called technical or legal requirements to the validity of these forms that take away rights. So are all the forms in order? It's your job, and you're representing these clients, to ensure that all the formal requirements in completing the relevant forms have been followed by the attending physician, and more to the point, to find gaps where they've not been followed, on which you can base a preliminary motion, which we'll talk about in a minute. So this really requires a careful review of all the legal forms in particular, though you absolutely must review the entire record, but that's for later. Sometimes obvious and glaring errors can escape your attention if you're not careful, so do look at everything, including, is the client's name on a Form 3 or Form 4? Is it correctly spelled? Is their address there? Now, for LAMDA members, I am going to share, along with this video, a very helpful cheat sheet. I think, Shira, you've seen it. That is
I
really...
can vouch for this cheat sheet. It is excellent.
Shira got to test drive it. Are you using it, Shira?
I am. It is great. It's helped me with also just flagging the preliminary issues, and it's so neatly laid out. I really encourage everyone to use it. I am a checklist person and love cheat sheets, and it is so helpful. Both if you're new to CCB work or very experienced, it's always helpful to use this as a guide.
Thank you, Shira. I'm glad you like it. So no matter how many you've done and how well you think you know everything, if you have a checklist, it forces you to go find each document rather than just looking through the record and seeing, oh, there's the Form 3, there's the Form 30 notice, there's the renewal of the Form 4 for a month. If you're systematically looking for a chain of flow of certification, for example, looking at a checklist will force you to look to see whether on the chart there's a Form 1, a Form 42, a Form 3, a Form 30. And as you start to do the work, you'll know what all this stuff is. So for LAMDA members, I had done one of these checklists a long time ago, a super long time ago, like 20 years ago. That was shared as part of the impanelment process. So I've updated that, and now it's really good. There will be a further iteration where I think I might create another column for cases of the CCB that will go with all these issues that you can spot. But anyway, for LAMDA members, I will share this with you, maybe on some conditions, we'll see. But you can also build your own. I think it is important to approach the review of the health records, looking for preliminary motions and issues and problems with the legal forms in a systematic way. You need to make sure not only that the relevant legal forms depriving your client of some right, but also the formal written notice of that change in legal status to your client have been completed and within the appropriate timeframes by the appropriate person and delivered to your client as prescribed by law. You should also be able to confirm by reviewing the record whether a rights advisor attended or was contacted to see your client promptly following the completion of any of those forms which require rights advice to follow, because failure to comply with these requirements may allow you to bring a motion leading to the revocation of a finding or a rescission of a certificate and restore your client's voluntary status or capacity, as the case may be. A particularly productive area for arguments of this nature are the requirements to file certification documents, for example, with the officer in charge of the psychiatric facility, and to review those certification forms. So for involuntary admissions, this is section 20 of the Mental Health Act, 20 sub 8, 20 sub 3. There's a lot of fertile ground there. It's very often that I find most hospitals will have some problem in their process of admitting people as involuntary patients, for example. So you're looking for evidence of filing and review available on the chart, which it often isn't. And you can get some really good results, rescinded certificates of involuntary admission for your client.
Okay, and we'll go into preliminary issues a little bit more, but we're still on the topic of reviewing the chart. So the first thing that you look for are technical defects in the forms. And then what do you look for in the medical records?
So you do need to review the whole record, and you're looking for the substantive issues that are being litigated in front of the board. So depending on the subject matter, if it's an involuntary admission, you're looking for the substance of what are the concerns based on the forms that you saw, what are the criteria that the doctor is saying they're going to rely on to hold your client. Is it bodily harm to others, to themselves? Is it suicide? Is it, mental deterioration? you have to find the finding of incapacity. If there's a treatment incapacity finding, you need to find the charting that relates to the assessment of capacity. So you're looking for the substantive charting that relates to the legal issue that's at the heart or the center of the controversy. So you're going to be reviewing this chart probably more than once. You're going to review it the first time sort of in a more holistic way than what I've just described, to get a sense of what is going to be the case against your client. And you do that after your first meeting with the client, just so you can get a sense of the client. Then you get a sense of the case against your client, and then you should probably check back in with your client, because at that point you're able to say, look, I've had a sort of reviewed the chart, and it looks like what we're going to be hearing is that, your mother went to justice of the peace and had these concerns. You sort of tell them, what the disclosure equivalent is in terms of the chart. So then it's also important to review the chart immediately before the hearing. So you probably do it a few days before the hearing, talk to your client. You're going to have to get updates as close to the hearing date as possible, preferably on the date of, but that depends on timing, or the day before. And the reason it's really important to get those last minute updates is that your client's mental state can change very rapidly, which can cut both ways. You may think you have a great case, you're in great shape for the hearing, not knowing that, on the day of the hearing or right before, your client punched a co-patient in the head and they're locked into seclusion and 4-point restraints. If you're not prepared for that, it's going to be hard to mitigate that. Conversely, you may have a sense that everything is lost, and then, miraculously in the couple of days right before the hearing, client has substantially improved, maybe has privileges, maybe he's going off the ward for hours, may even be prepared to continue as voluntary patient. So you go through the chart, you read all the doctor's notes, thank goodness now they're all typed, it's all electronic. So you read the psychiatric progress notes, any discharge summaries from previous admissions, either to this hospital or elsewhere, and nursing notes, all the charting notes from multidisciplinary professionals, nurses, social workers. Those are very important. They tend to be more detailed than the psychiatrist's notes. And will detail as well your client's interactions with other patients, general concerns. Keep in mind, the general rule is that if it's not charted, the behavior did not happen. So at the hearing, if doctors start referring to all kinds of incidents involving your client and you've reviewed the whole chart and you know that it's not charted, you can confidently say to the doctor, where is that charted? Please refer me to the charting note, because they'll have access to the whole record on their laptop or on their computer at the hearing. So knowing what is not in the chart is just as important as knowing what is in the chart. So your cross-examination ultimately at the hearing will really benefit from having a solid idea of the kinds of notes and the content of the notes that the psychiatrist and nursing staff have made about your client.
Just as important to look at what's there as what's not there.
Absolutely.
So you look at the medical records. After you've reviewed the medical records, do you speak with your client again?
Yeah, I think that's really important. So after reviewing the chart, meeting with the client for a second time, or talking with them on the phone or on Zoom, you're now in a position to advise the client what the attending physician or healthcare practitioner will be relying upon to support their position to detain or treat your client against their will. And you should try and get your client to respond to each issue that's raised by your review of the records. Together, you can then develop a strategy for approaching the hearing, pick your strongest points, and proceed to formulate a theory of your case. Do not leave this interview without knowing whether your client might contact witnesses themselves, or whether the client has documents that they would like you to enter as an exhibit at the hearing, so that you can review stuff. I mean, often our clients in person anyway would show up and hand things to the board, or hold up on the Zoom messages that they want people to read. It's good to have a conversation about what will help in terms of evidence and whose evidence might help. So if your client's contacting witnesses, you want to know about that. If they want you to contact witnesses, you want to know about that. And you want to make sure that the client knows how to get a hold of you between now and the hearing, and that you know how to get a hold of them or anyone else that you may need to speak to. And you just sort of go through, the substance of the case, and make sure they understand what they're going to hear so they're not upset hearing it for the first time, because these hearings can be very difficult and traumatic for the client, particularly if they're not prepared in terms of what's been written about them and what's going to be tendered as exhibit information by the doctor at the hearing.
That's a really good point, because we often look at this as lawyers, as professionals, but these are clients that have had their rights taken. They're in a hospital, they're detained involuntarily, and then it feels like their whole existence is on trial when they're going through this process and hearing someone speak about some of the negative behaviors they've had, and some of the what they've been exhibiting, and either saying that they're dangerous to themselves or other people, and it can be quite difficult to hear. So that's a really good point about being sensitive to your clients and ensuring that they're prepared for it in that way, and trauma-informed lawyering.
Yep.
So with that as well, I want to ask you, because sometimes a client's behavior can affect an outcome at a hearing. During that conversation, do you also talk to them about the hearing decorum and how they should behave during a hearing?
Yeah, it's interesting because at the hearings, oftentimes you'll hear CCB chairs in particular, part of their standard introduction is sometimes, we need to make sure that people don't talk over each other because of the court reporter. That's fine. But sometimes they say, don't interrupt if someone else is talking. And they sort of start from the presumption that maybe the client's going to be disruptive. Or if there is some disruption, I think I sometimes find CCB chairs assume that it's my client who's unmuted and that's where the noise is coming from, when it could actually be from anywhere. So I wouldn't spend a lot of time on that. I wouldn't sort of caution against that. I'm more likely to say, keep in mind that you might hear a lot of things at this hearing that are going to upset you. You're going to hear the doctor say things that you don't agree with, that you really disagree with, that you think are not true about you. So you may not want to be there. You have the choice of, for example, not being there when the doctor is testifying, and I can give you a quick call or a text and you can come and testify after that. So I talk with them more about that they're going to hear things that are upsetting. Yes, if I think I have a client who's, more likely to interrupt, and I can tell that, I might say to them, that's not going to help your case. So if you think you can't not interrupt, then you may not want to be there. Or you might want to mute yourself if we're on Zoom. It was more difficult. And in a way, well, it cuts both ways. In person, it was easier to sort of, just tap the client sitting beside you. Can't do much with them on Zoom, but they can very easily remove themselves when they're overwhelmed on Zoom, where it was just harder to physically leave.
All right, so Anita, with all this information, how do you prepare for a CCB hearing?
Right. So there are a few things you want to consider in preparing for the hearing. So you've gone through the record, spoken to your client. You might give some thought to whether or not there is a solution or resolution or settlement of the case that may be reached. But you have to know from your client if they consent to you speaking to the doctor before the hearing, because you don't want to just reach out to a doctor, have a conversation, have a whole potential settlement. Your client doesn't know anything about that. So depending on what your client wants, if they want passes, if they want treatment with oral medication as opposed to injectable, there may be things that you can negotiate. There may be things about the hearing you can negotiate. There may be things that your client really doesn't want happening at the hearing that you can ask the doctor to take into account. whether, it's the family that you don't want to be there because it would be upsetting for your client. So if your client says, yeah, sure, you can talk to my doctor, that can sometimes be really helpful. If your client says, no, I don't want you speaking to my doctor, obviously you can't do that. Now, all the doctors will be different in terms of their approach. Some will refuse to talk to you anyway. I've had them ask me if I'm going to pay for their time if they're going to be required to speak with me. But certainly your client has the right to know how this hearing is going to unfold and what's going to be argued by the doctor. Now, you'll eventually get a CCB summary from the doctor, but you don't get that or the documents along with it until 10 a.m. the day before the hearing. So if you can kind of find out what the doctor is going to present here, if they'll have witnesses, it's a good idea to ask about that. Of course, you'll have a sense from your full review of the clinical record, but what you may not realize is the doctor may be only too happy to avoid a hearing altogether and would like to settle the case. And some doctors are really nice to work with, and you get to know them over the course of your career. They may well understand the importance of the hearing process and try and work on an acceptable resolution with you. So making that first call is often worth the effort. How else you can prepare is you can create your own little cheat sheet of the evidence, even though you'll get the CCB summary and the templates and the records and the exhibit package. Sometimes it's a really good idea to create a single sheet of paper, or obviously on your laptop, as one pager, where you have all the really important dates, a short list of important dates and other significant information on a single page in preparing for the hearing. That list could include minimally your client's diagnosis, the medication regimen, the date of this and the most recent admission, dates of relevant forms being completed, by whom, short summary of the history of your client's hospitalization on this occasion. And it's useful to think about and plan out your submissions based on your theory of the case. So drafting your submissions in advance of the hearing, you're not going to stick to them. Obviously, there will be a hearing. There'll be evidence that unfolds that'll change things, but having a draft of your submission will force you to revisit the relevant legislative provisions, because in your submissions, you may want to say, obviously, these are the criteria that the Mental Health Act requires, or the test for capacity is this. And that grounds your submissions. So working on your closing submissions and having them set out is really good, particularly as you're starting out in the area. For the first little while, it's a good way to train yourself to do things. And it also reminds you that the onus is on the physician, which is sometimes easy to forget. And you bring it back to, it's the doctor's onus to prove on a civil balance of probabilities what they're trying to prove at the hearing. So those are some things I do. And then we'll talk about how drafting your submissions assists you in preparing your cross-examination, but we'll talk about that in a minute.
Okay, and then, so you prepare for the hearing. What's the structure of a CCB hearing?
Yeah, that's a good question. So these days, the hearing will most likely be on Zoom. Still, some facilities, it could be on the phone. The panel, the consent and capacity board, the tribunal itself, will consist of 1, 3, or 5 members, depending on the matter. Sometimes it's just one lawyer member. That's a senior lawyer member of the consent and capacity board who is entitled to hear capacity matters under the Healthcare Consent Act. If it's an involuntary admission, a Form 16 under the Mental Health Act, or a community treatment order review, that requires a quorum of 3 members, a lawyer, a medical professional, whether it's a psychiatrist or a nurse practitioner, and a community member or public member who's not a medical or legal person. The exhibits that the doctor has filed and anything that you filed will have been sent to the panel in advance. So the hearing will open with the panel marking the exhibits. The summary the doctor has provided, CCB summary and exhibits. Any documents you've provided, they might refer to cases that you've sent in, which we can talk about in a minute. And then the doctor presents their evidence. Often they don't. They've really been encouraged, I think, to just say nothing, because we're hearing a lot of, I rely on the written material that I've sent in. and they don't testify, which leaves you, in a weird place because you're cross-examining someone only on their written material. Or maybe they will testify. They're most often unrepresented by counsel. At some hospitals, they will have counsel. Sometimes they will have outside counsel, but most physicians at these hearings do not have counsel. So they will testify. You can then cross-examine them, talk about that. The hearing panel can ask them questions. It's meant to be an informal process. There's some question. This is a very long story. I've just spent several weeks researching and writing about. So we won't get into it, but there's some question about whether this board has an inquisitorial role or not. So kind of circumscribes the kinds of questions that the board may be asking. Often it's just for clarification. Sometimes it's a bit more probing than that. You get the feeling they're trying to shore up maybe the doctor's case a little bit. And you might have to object or push back to make sure that those questions are more inquiring and more neutral. Your client has the right to present their case. The doctor may call other witnesses. They may call other professionals like social worker or nurse to testify. They may call a family member, a parent, or a spouse of your client to testify against your client. That's very difficult. And then your client can call their own witnesses and or they can testify themselves. The problem is there's a strict time limitation and a cap of 2 hours now on these hearings. So it's, 9 to 11, 11 to 1, 1 to 3, or whatever it is, 12 to 2, 3 to 5, whatever it is now, the current time slots. There are only 3 hearing slots in a day now, I think, and they're capped strictly at 2 hours. So you have to kind of be judicious with how you will use your time, or ask for a case conference and ask for a half-day hearing or a longer hearing if you're anticipating a lot of witnesses. But either way, your client's going to have a hearing. There are some people who think that there's real therapeutic value in your client having their chance to speak. I'm not sure about that. Most of the time, I will advise my clients not to speak because my experience is that they just want to win. So I do try and give them advice on how to win. In terms of other documents at a hearing, sometimes doctors will include letters from family who are not being produced and made available for cross-examination. You can fight about the weight of the evidence to be given to that kind of document. What else happens at hearings? Structure of the hearings, you may not get a lot of breaks. On Zoom, your client can just get up and leave. A lot of our clients still smoke, so you have to be mindful of the fact that they may need breaks. Make sure you get instructions to continue in their absence if they're okay with that. Otherwise, you have to stop while they do take a break. But it is important for them to have breaks for a host of reasons. Medications make their mouths dry. Maybe they need water. Maybe they need to walk around. Maybe it's a difficult process. They need to be off camera for a while. So just be mindful of that.
And also with breaks, do you take a break at some point during the hearing to speak with your client?
Yeah, so that is actually the beauty of Zoom, certainly over phone, is you can have a breakout room and meet with your client privately. It doesn't take a lot of time. In-person hearings, you obviously have to go find somewhere private to speak, and you end up spending a lot of time sort of doing that. So you absolutely should, in every case, speak with your client once the doctor's case is finished in order to then determine whether your client wants to testify. They have the right to testify. And as long as you advise them about the pros and cons of doing it and the risks of doing it, it is absolutely their right, as it is their right to be present to testify if they wish. And so at that point, you must check in with them after the doctor's case is finished to see if they want to testify, because they do have that right.
Okay, and going as well through the structure of the hearing, we did discuss preliminary issues, and I want to go in sequential order with how you may deal with the hearing. So can you give a brief explanation on dealing with preliminary issues at a CCB hearing?
Yeah, it's actually, such an important question right now, and it's very difficult to answer the question right now because there are a lot of moving pieces within the CCB's sort of published policy guidelines, practice directives, rules of practice. and some of their unwritten policies and guidelines in terms of how they will receive and deal with these preliminary issues. But in in my practice and in my opinion, it is important to give notice. We are required to give notice of any issue that we think could or should be dealt with preliminarily at the beginning of a hearing. We have to do that, and this is a bit unclear on the board's website too, but we have to do that by 2 p.m. the day before the hearing. So we get the doctor's materials by 10 a.m. and then we have to serve and file these motions by 2 p.m. And basically anything that you think is an objection based on the legal forms, the technicalities, a breach of the provisions of the Act, your client didn't get rights advice, or they didn't get it promptly, or there wasn't a filing with the officer in charge, or there's no chart notation documenting a capacity assessment of financial capacity, whatever it is, something that if you have the documents to prove it and the arguments and the cases to support your objection would dispose of the matter without need for a full hearing, then that is something you should give notice of by 2 p.m. the day before the hearing, setting out the grounds. I will be bringing forward a preliminary issue that my client's certificate of involuntary admission is void because the Form 3 was completed outside the 72-hour clock of their Form 1, and they were not told that they were free to leave or voluntary in between, and you would cite Doherty, install the case and attach it, something like that. So I think it is important to make sure that where there is an issue like this, that you do raise it, because if your client had the opportunity to raise it and they chose not to when they have a hearing, or you didn't spot it or raise it for them, they can't next time they have a hearing raise it because they didn't raise it when they could have. So you want to be careful around that. With community treatment orders, it is important to try and bring these issues forward. You may find that they are not heard at the beginning of the hearing, and I think this is something we'll talk about in the community treatment order episode because it's just a lot. So those are just some examples of how you would approach and when you might approach a preliminary issue.
And on that point of sending material by 2 p.m. the day before the hearing, do you also send case law on some of the substantive issues before the hearing, or do you save that for the hearing itself?
So that's a really complicated question. It's a loaded question because I personally don't like to send cases in advance. I think there's no obligation on us to do anything or to disclose our case. There's no reciprocal disclosure obligation for patients. By sending cases, you might flag things that you wouldn't otherwise be fleshing out the extent of these arguments. Like, it's not meant to be a complete argument. It's not a factum you're filing. You're just flagging the issue. However, if there are cases that support your point, and sometimes, we'll be using the same cases over and over again because there are 3 or 4 core cases that support a particular point. So if you are filing these preliminary issues, then you might as well file the cases. You can also just hyperlink to the cases like you would in a factum for the Court of Appeal. So you can literally just send an email saying, I'll be relying on the following cases, and just hyperlink to the CanLII version of the case without, explaining it. You do have unrepresented physicians on the other side. So as a matter of professional courtesy, it's actually probably important and helpful and professional to provide the cases on which you may rely so they have an opportunity to review it. Because otherwise there's always the risk that if you just start referring to them in submissions or email them in submissions, the board may say, well, the doctor didn't have an opportunity to review these. We didn't have an opportunity to review them, so we're not going to consider them. I have seen that. So after all, the best practice is probably to at least name the cases, flag the cases, and allow for someone to go to the cases. But you don't have to do a lot more than that. If something is really, really important and really novel, we might send the actual case and highlight or sidebar the relevant passages and go, a step further. But that's rare.
Okay, so we've discussed some of the structure of the hearing. You start the hearing, the chair will give an introduction to the format of the hearing, then you may deal with preliminary issues, documents are admitted as evidence. The doctor may testify, may give a summary of their case, and then the floor passes on to you to cross-examine the doctor. So can you give some pointers on cross-examining doctors?
I can. So, Shira, part of the 7 part series that we're doing, we're going to roll around to having some demonstrations of mock cross-examinations, I think probably, hopefully, as part of each session. I really want to do a cross-examination clinic specifically for lawyers representing patients at the Consent and Capacity Board. I read a lot of transcripts. I'm worried about how lawyers for patients are so nice in these hearings. You don't have to be mean, you don't have to be cross, you don't have to be hostile, but you also don't have to be afraid of upsetting the doctor by asking proper cross-examination questions. It is an adversarial process in that there is an onus-bearing party, the physician or whoever made the finding. Your job is to probe and test the evidence as if this were a criminal law file. You're putting someone to the proof of something. So it is a bit exhausting to read all these transcripts from CCB hearings with open-ended questions that lawyers are asking doctors, like, how would you describe my client's symptoms of schizophrenia, doctor? No good comes out of questions like that. You must never ask questions like that. So my thoughts on how to cross-examine witnesses, I've sort of put these notes around out there. You'll find them in places. These notes go equally for expert witnesses like psychiatrists. So here's what I would do. I would begin by writing out what I want my closing statement to the board to be at the end of this hearing. The facts that I would review with the tribunal that I would rely upon, and the law that I would be relying upon. I would take the facts part and separate it into bite-sized bits of 5 words or less. I would type this up with bullet points or write them out. This should go without saying, but I am amazed at how many lawyers don't actually appreciate that a cross-examination question is a pointed question. It's a closed question. It's a question that suggests the answer. And hopefully that answer is yes. So when you're preparing a cross-examination, they don't actually have to be real questions, right? And this is I find a common problem that younger lawyers sometimes have, is they think they have to ask a question every time. These are just statements. You can just put a series of statements to the witness. So for example, rather than saying, what can you tell me about my client's psychiatric history? You can say, if you review the record, and this is a first admission, a first psychotic episode, you can say, my client has no psychiatric history. You don't have to say right or correct or isn't that right or I suggest to you. You can just say, my client has no psychiatric history. And the person will say, that's right. He's never been certified before on a Form 3. That's right. He's never been medicated. No. Never been violent. Never been charged. Never been convicted. And you just go through to establish whatever you need to do systematically, as you would with any good cross-examination. Again, you don't have to be mean. You can be charming, you can be polite, but you can be firm. So my advice is, sorry, Shira.
I was just going to add in, I mean, it's cross-examination. This isn't direct examination.
Yeah, and I find that because it's a medical environment, because there's a therapeutic relationship between the doctor and the patient, because we have a tribunal that doesn't like discomfort and they get worried if they feel like the doctor is being attacked just because the lawyer is cross-examining the doctor. I've had board members interrupt me to say, Miss Szigeti, ask more open-ended questions of the doctor. And I'd be like, why? And then they've said to me, oh, you're confusing the doctor. Great, like that's my job. They say, yeah, but the doctor can't get his evidence out straight. So, you have to help him to put his story together. So our job is to confuse them. We're not there to assist them. But a cross-examination because it's a good cross-examination and they're leading pointed questions, getting at the answers that you want, that those questions suggest, is not an abuse of an expert witness. It's not rude to the physician. It's not personal. It's not an attack. And if people perceive it that way, that says more about them than it says about you. I find in this area of law, lawyers tend to think that they're, doing something therapeutic, something helpful. They want the patient and the doctor to get along. They want the doctor to get along with them. They want everything to be nice and friendly in the hearing room. And for some reason, therefore, ask only open-ended questions. What do you suggest? How long do you think before he could be voluntary? What do you have any other ideas about medications? That is not litigation in a forum where somebody has an onus and you're trying to put them to the strict proof thereof, right? So we all know how to cross-examine. Feel free to cross-examine. Your client wants to see you asking questions that get the answers that they need. So let me just see there. I'm really exercised about the cross-examination, and I promise I won't talk much more. But I did want to say, please don't ask open-ended questions. As you're a new lawyer and you're starting out, just ask 0 open-ended questions until you're able to ask them in a way where you can control the witness. Expert witnesses, doctors are funny. If you give them an opening, they will not stop talking. So as soon as you give them an open-ended question that doesn't suggest a yes or no answer, they're going to get away from you. You're going to lose control over them. So keep your cross-examination questions to 5-word bullets and just hammer them home as politely but as firmly as you can. And you can keep repeating your questions exactly as you put them. If they're not answering them, make them shorter each time for so long as your witness remains unresponsive. And then a really fun little trick that I learned from the best, who was my former law partner, that really makes everyone in their hearing room uncomfortable. But if you want the witness to learn to behave next time, and they give you a 20-minute answer to a simple question and will not stop talking, you wait quietly and nicely. You don't interrupt. And then once they're done, you don't ask anything for a while. You just sit for about 20-30 seconds quietly yourself. And then you say, you finished? And they'll never do it again. So that's a helpful tip.
And it is important to remember that your client has requested a hearing. They are there because whatever their current situation is something that they don't want to see continue, whether they're hospitalized involuntarily, whether they have a CTO, whether the doctor made a finding of incapacity, they don't want that to continue. That's why they have brought upon a hearing. And psychiatrists know, as part of the process of forming a client or to them a patient, that there can be a hearing. This is part and parcel of the professional system that we are a part of. So it should be remembered that there is a difference between being adversarial, because it is an adversarial process and the doctor has the onus, and being antagonistic. And being a good advocate will involve cross-examining. It will involve pointed questions, the leading questions. And it doesn't mean that you are attacking the doctor as a person, you're attacking their profession, you're attacking their medical input. You're just asking pointed questions to show that they have not met their onus in your client's very specific case.
100%.
So, yeah, so now just moving on, we had discussed before whether or not you would call your witness or your client as a witness rather. So when is it beneficial to call your client as a witness? I know you said more often not, but when would you call your client and how do you prepare them?
So almost never is my experience, but there are a couple of situations where it's almost necessary. If there's a finding of incapacity and the charting notes the doctor made about your client's assessment of incapacity do not reflect how your client would discuss these issues, because you've spoken to your client and they are clearly capable, and there's no cross-examination that's going to bring out from a doctor the answers that accurately reflect your client's capacity if the doctor is going to base it on their charting and if there's going to be nothing to contradict them. So if you have a client who's going to present as a capable individual, whose evidence will be really compelling, and it will make whatever the doctor had to say completely forgotten, then you need to call your client and demonstrate their capacity. So if you have a client who's going to present well, it's going to be hard for the hearing panel to find your client not capable in the face of their direct evidence. Now, they'll still do it sometimes. They'll say that, your client was coached, or they knew what to say, or this is a brand new insight and it's not to be trusted, or maybe they're mouthing the right words, but they, talking the talk but not walking the walk. That's one time that it's helpful to call the client's evidence. Another time is when there are allegations about things that your client did that your client really denies, and your client has a perfectly reasonable explanation for what happened and their conduct and why they did certain things. They have an alternate explanation that is sensible and makes sense. Then it's helpful sometimes to have them tell their story, if they're going to be able to do so by communicating it clearly and it's going to be persuasive to the tribunal. As for your question about how do we prepare them as witnesses, we try and prepare them as we would anybody else. Tell them there may be cross-examination questions for them. Tell them to only answer the question that you're asking them, not to volunteer answers to other things. Tell them to testify honestly and to let you lead them through their evidence in chief. And if you're going to have them testify, have it be as short as possible, so as not to overwhelm them, so as not to open a lot of doors for cross-examination. Although doctors often don't ask a lot of questions of our clients, but they have the right. I was just talking about this the other day. My favorite transcript that I've ever read was an incapacity hearing where the doctor was representing herself and the client was testifying about the medications he was taking and why he didn't want them. And the doctor chose to cross-examine the client. So she was asking him, well, how do you feel about the medications? Do you think they help you at all? Don't you think they help you? Well, what side effects do you have from the medications? Do you think the side effects outweigh the benefits from the medications? Will you be taking the medications? And finally, the client just said, why are you asking me so many questions about the medications? And then he said to her, is it because you're thinking of taking them?
Oh my gosh.
It was so earnest, because he was just like, she's so interested in my medications and how I feel about the medications. Maybe she's thinking of taking them. He was like, I'll tell you more if you're thinking of taking them.
I love that.
They're so cute.
That's adorable.
They are. They can be, yeah.
So next step of the hearing, we go into submissions. And what do you hope to accomplish from making your submissions?
So submissions at a CCB hearing are actually your opportunity to shine. This is a comparative advantage that you often have over an unrepresented physician. They don't know how to make submissions. They'll try and sneak in new evidence that they didn't mention in their evidence because they can't tell the difference between a submission and evidence. If your client is there, they may or may not appreciate what you were trying to accomplish through your cross-examination, but they will for sure understand what you're trying to do in your submissions for them when you're asking them to be released, when you're asking them to be found capable. This is the moment where your client really feels your presence and your advocacy on their behalf. So you should not feel shy about the kind of time you're taking in submissions. You should make full submissions, even if there's time pressure and the doctor has chosen not to make submissions, which they often just say, I rely on my evidence. There is real side benefit to comprehensive submissions. I'll tell you why. I, in the past, have done a lot of appeals from CCBs. I did one today. I haven't done one for years because of case lines, which I hate. But if a case from the CCB is going to be appealed, comprehensive submissions with the arguments from counsel in closing at the moment when they're fresh in the mind of that lawyer are super helpful. So making full arguments, and you'll get the transcript of these submissions when the appeals are launched. So it's for the record, so an appeal can be done and informed with your submissions, but also for your client to really be proud of you. And you just make your case. You've got it drafted from your preparation. You make your case about why they have not met their onus. The doctor hasn't met their onus on a civil balance of probabilities. They don't have clear, cogent, or compelling evidence. Here are the cases that support you, why they should prefer your client's evidence if they testify, and why the legal criteria are simply not met. So you should make good submissions. It's a really important part of the hearing that is often ignored.
And that's a really good point too about the client management aspect, that's when the clients really hear you advocating for them. And I can say from experience that multiple times clients have told me after the hearing that they really appreciated hearing that advocacy on their behalf, because until then, it's been what felt like an attack on them. And so to hear someone talking about the positives and how they don't necessarily meet the criteria for being formed or whatever else it is, to know that there's someone saying that means a lot, because they've been metaphorically beaten down quite a bit going through this process. So this is something that can go a long way for your client. And now, so you've made your submissions. Next step, of course, is getting a decision. So what's the turnaround time to get a decision?
Yeah, well, sometimes it's just a few minutes. So disappointingly, we have definitely seen, a hearing come to close on Zoom at, 11 a.m. and at 11:02 a.m. there'll be an email that we've lost. My personal thoughts on that is tribunals should hold on to the decision, even if they've determined the moment they close the hearing. They should pretend to deliberate, even with themselves. I think it would be respectful of the client to wait 5 to 10 minutes before they lose. So sometimes they come right away. They must come within 24 hours. So we get a decision very quickly from this tribunal.
And it's important to get a decision quickly. For example, if someone is detained involuntarily and it's a decision to rescind a form, you need to get a decision quickly, because that can involve someone's liberty interests.
Absolutely. And actually, one of the things that we've been struggling with sort of just procedurally is I've heard reports where doctors are not providing email or fax or phone contacts for themselves, but rather for like a health records department only, which means if we have a Friday afternoon hearing and a decision comes in on a Saturday morning, some clients are detained until Monday when someone returns to the office to notify them of that decision at the hospital. So it is important for us to at least be able to get that decision, whether it's the weekend or nighttime. However, the problem we have then is just because we call up the unit and say our client's free to go because we say so, they may not trust in that. They may call a doctor, have them reassessed. They may not be available. So there's a lot of client management that happens when you win a hearing. There's really not a lot to do when you lose, but you'll get the decision quickly.
That's a really good point. And then often we'll get the decision. It's a form and the doctors will type a little X over whether they agree with your position or not. And but they don't provide reasons. It's just a little paper that says whether the doctor's finding of incapacity is confirmed or not. So that you don't get any reasons, but is there an opportunity for you to get reasons for the decision?
Yep. You can request reasons for up to 30 days, I think, from the date of the decision or the date of hearing. I actually can't remember, but that's one day off. So 30 days to request reasons. Everybody has their own different practices and policies on whether or not they're going to request reasons. Over the years, I personally have determined to only request reasons when I win. I didn't like the way the law developed when I was losing a lot of things, and we'd get very interesting interpretations of the law to result in a loss to my client. I didn't think that was helpful to the evolution of the CCB jurisprudence. wasn't helpful for my client. Nobody wanted to read the reasons for that loss. So I stopped asking for reasons when we are not successful, unless, of course, my client wants to see the reasons for the board's decision making. Then win or lose, we request those reasons. But I think if we just ask for them when we win, we build an interesting jurisprudence that way. Looks a lot better than it is, but at least it's happy stuff.
I agree. It gives us more that we can use in our arsenal for our future cases.
That's the thinking.
And so, as you mentioned, often cases don't necessarily go our way, and that's when the issue of an appeal would come up. So what goes on with an appeal? Is there a deadline for filing notice of appeal? And can you explain the conversation with the client about their right of appeal?
Yeah. So we do all have to speak to our clients about the right of appeal. Um, it is an extremely tight timeline. It's 7 days from receiving the decision of the board, not the reasons. So it's actually almost impossible to give an informed opinion about the merits of an appeal, because the board has 4 business days to give reasons after you request them. So if you ask, the day the decision comes in, you request the reasons, then you may get the reasons, maybe if you're lucky, 1 day before the deadline to file the appeal on the 7th day. It is actually also tough to file an appeal now with online filing, but you speak to your client. I personally would never appeal an involuntary admission, almost never, unless they've been in for 10 years on their 850th 3-month form and there's some big legal issue with a charter twist. But apart from that, I would not appeal an involuntary admission decision of the board, because they don't get CCB hearings pending the appeal. They get these shadow certificates. They don't have the right to a hearing. So I would not do that myself. Some people do. Treatment incapacity is most likely to be appealed. You do have to talk to your client about the implications. If you launch an appeal, you cannot get treated if you've not been treated up to the point of the hearing. For that reason, many clients will want to file a notice of appeal to stop treatment or to not have it started. And then I think we're going to have a session maybe that focuses on appeals, on what the next steps are, but you should speak to your client. If they instruct you to file a notice of appeal, you should prepare that for them. Preparing it is not that hard. Filing is a bit difficult. But if you need to stop your client from being treated, then you need to file that notice of appeal within 7 days of the decision.
Okay. And then, generally speaking, are there any specific things that all lawyers doing CCB work should know before getting into a hearing room to do this work?
Yeah, that's a good question. I think Shira, that we will have a separate session on this, and you will lead this session and you will present in the session. But probably the biggest thing that you do have to know, and in a way you'll learn on the job, but what you can pick up before you start is the medical stuff, is the psychiatric lingo, the various diagnoses, and the DSM-5. For me, this is really second nature now, but that's 30 years later. It is something to learn at the beginning. The medications, what is a long-acting antipsychotic? What is a neuroleptic? What is a depot medication? How often are these medications given? What are some medications that can only be given orally? What does that mean? The different signs and symptoms, and the effect of substance use and different substances on symptoms of mental disorder. So I know, Shira, that you've got a whole presentation that you can do on this, and I think you should. So some exposure to the language of psychiatry and some of the basics of mental disorders is probably important to know. And other than that, you should probably know something about the client population. And I think we'll talk about that next. And so we're almost done. I think we're coming to the end of our introduction to CCB. It will be almost a full 2 hours, and it's going to, I think, maybe probably best taken in chunks. So you have a couple of questions left. I think we're going to talk about client relations, and then we're going to let everyone go and hope they've learned a lot and buy some books.
Yeah, and so stay tuned. There will be a Psychiatry 101 CPD for CCB lawyers, so that will be coming in the future. But in the meantime, what are some important considerations in how to approach the representation of our vulnerable clients who may be experiencing a mental health crisis at the time?
So, there's a lot that can be said about this on the one hand. On the other hand, I think the best thing you can do is speak with your clients as you would any other client and just treat them with tremendous respect. My approach is very formal. It's always Mr. Ms. So and so, unless and until I'm told otherwise. I'm always Anita to my clients, and they are their full last name, and I ask how they want to be addressed. Very respectful and very mindful of the client's desire and need to be in control of something in their life. They've had control taken from them in every respect of their life. Most of our clients are trauma survivors. They've had major trauma in their life. A trauma-informed lens on the representation is really important. So I understand that they've had their decision-making rights taken. They have psychiatrists trying to make decisions for them. Their families have made decisions for them. People try to tell them where to live, whether they can go to school, who they can date, what they can do with their bodies, what medications they're going to be forced to take. If they're on community treatment orders, a lot of things are compelled for them. And the other thing that really bothers our clients is this business that they don't know what's good for them. So what's really important, in my view, is to let them know that you're the lawyer, they're the client, you're there to do what they instruct, they're in charge, and you want to hear what they want out of this hearing. And you will fight for them with a straight face, whatever they want. You're not there to talk them out of trying to get their rights brought back. You're not there to do what you think is in their best interest. You're there to try and get them the result that they want. And if they feel that they're in control, that's something you can give them that other justice system participants won't.
And that's a really good point. You said best interest, and it's not a best interest test. It's a matter of if the legal test has been established. So it's important to highlight that to your clients. One thing I often say to my clients is, I'm like their Uber driver. I might be the one behind the wheel. I might be the one doing the driving, but you're the one telling me where to go. And it's good for them, helps them feel like their voice is actually being heard when they're working with you.
Yeah, 100%. And I think we're on the same page here in terms of what's the most important thing in terms of, I think the last thing we were going to talk was ethical representation of clients. And really, it's just about client instructed advocacy. So you're not there to impose your judgment of what you think they need. You're not there to take instructions from their parents or their family about what they think they need. You're there to represent the client, same as any other client, based on their instruction. They're deemed capable to instruct you pursuant to the Healthcare Consent Act. So you don't have to worry about whether you're getting capable instructions. And you just go forward and stand between the client and the healthcare system and the justice system and the tribunal. And you're that buffer where you're forcing people to deal with you as an advocate for your client in a fearless and zealous way, taking seriously the professional conduct rules that the Law Society ascribes to advocates for vulnerable people. There's a lot to be said about this. We, I think, have touched on all of the important parts in a way that is hopefully going to be helpful to new lawyers or young lawyers, and as a step-by-step guide to introduce them to the practice of consent and capacity board representation of patient applicants. But that's the most important thing. It's client instructed advocacy. They instruct you. You don't tell them what you think. What you think doesn't matter. They should never know what you think about whether or not you think it's a good idea they take their medication, good idea to stay in hospital. Your opinion doesn't matter. They don't need to hear it. The tribunal doesn't need to hear it. You shouldn't even have an opinion. You should find out what your client wants and try and get it for them. So I think that's all I have.
Well, thank you, Anita. This has been such an instructive seminar. You've been a wealth of information and always a great advocate for the mental health lawyers, both lawyers that are doing mental health work and also for our clients. So this has been really great tonight, and I want to thank you so much. And we look forward to having LAMDA members join us for the next seminars in this series.
Thank you, Shira, so much for the idea and for taking the time to have this conversation today. You've been great, and I'm so grateful. Thank you so much.